Welcome, everybody. Thank you for joining me live today. We are going to be talking about 3 estate planning techniques to protect assets for your spouse. My name is Lynn St. Louis, and I am an estate planning and elder law attorney at ELG Estate Planning. We serve clients in the Spokane area, in Kennewick, Seattle, and in North Idaho. And our area of practice that we focus on is estate planning and elder law. What we're going to be talking about today are things that really concern the clients that we serve, which is how do they make sure that they've got the right estate plan in place to protect their spouse, both while both spouses are alive and after one of the spouses has passed. And some of what we're going to be talking about today are the concerns that clients express to me. So I'm going to be sharing those with you, along with the strategies that we use to make sure that our clients and their assets are protected. What we'll be talking about today are estate taxes and how to avoid them, so that when you're gone, you protect your spouse, that they don't have to pay state estate taxes. We're going to be talking about what probably is a bigger concern for most people, which is long-term care costs. How to make sure that your spouse is not left with nothing should, after your death, they need long-term care for whatever the condition may be. Dementia, or, there's a myriad of reasons that people need long-term care, especially expensive long-term care. And then thirdly, what we're going to be talking about is, all right, well, what estate planning techniques exist to protect assets while both spouses are alive and yet one person needs long-term care? What do we do in that situation? So let's go ahead and get started. First thing we're going to talk about is, how do you make sure that your estate and your spouse doesn't get saddled with unnecessary estate taxes? You see, I've emphasized state. The reason for that is, and as I mentioned earlier, we serve clients in Washington State and in Idaho. Well, Idaho doesn't have this concern because Idaho does not have a state estate tax. So Idahoans are concerned only with the federal level, which is over $12 million per person. So if you have an estate of over 12 million and your spouse has an estate over 12 million and you live in Idaho, definitely you are going to want to see an attorney, a taxable estate attorney, who will make sure that you employ strategy so that you don't have to pay any federal estate tax if, for example, you have 24 million and you both are killed in an accident. That really is not what we're going to be focusing on today. But I did want to point out that if that is a value of your estate, you want to have an attorney with tax expertise, making sure that you're not paying unnecessary federal estate taxes. So let's focus on Washington State, because unlike Idaho, Washington State does have its own estate tax. And the level of that, what we call a credit exclusion amount, meaning what can pass free of any state estate taxes, is $2.193 million. I know that's a really weird number, but that's what it is. So let's say you and your spouse have more than 2.193 million. It doesn't have to be, double that. It doesn't have to be triple that. Just say you and your spouse have more than 2.193 million, but less than 12 or 24 million. You might be surprised that you have that much. A lot of people, frankly, are, especially when they look at how their investment accounts have done and what their real estate now is worth. And people that don't consider themselves rich at all have a taxable estate from the Washington perspective. So what can you do to protect assets for your spouse and also for your beneficiaries after you're gone. So the best or easiest planning that you can do is have a will that includes with it a certain type of trust. It's either called a credit exclusion trust, a bypass shelter trust. All of that lingo means the same thing. And let me explain how it works. So you and your spouse each have wills that contain these tax protection trusts that I just described. You're a Washington resident. Let's say that you and your spouse have $3 million and one of you dies. If you don't have a will with the tax protection trusts in them, let's say you die, your spouse inherits from you. Together you had a $3 million estate. When you die, because you are married, there is not going to be an estate tax imposed. But your spouse has now inherited $3 million, not just their share, but your share. And if your spouse passes away with $3 million, there is going to be Washington state tax, estate tax imposed on almost $1 million. That's a lot of money to pay, and be it starting at 10%, going to 15% to 20%. There's a sliding scale. Let's just say it's 10%. That's paying an extra $100,000 on the second spouse's death, all because they didn't have the right kind of wills in place to make sure that when the surviving spouse died, that there wouldn't be any estate taxes paid to the state of Washington. So if you have what we call an I love you will, which means everything goes out right to my spouse, no protections, no trust. Or if you have a community property agreement, which frequently people do have in Washington, that says, on my death, everything just goes to my spouse easily without the need of probate, really simple. Yes, that will accomplish your spouse inheriting everything from you, but they will inherit it without any protections against myriad risks, including the very real estate tax that will be imposed on your surviving spouse's death if they do nothing further to, for example, give away their money, which oftentimes people aren't inclined to do during their lifetime for a lot of reasons. So $3 million estate, what should you do? Have a will that has in it these trusts that I talked about, the tax protection trusts. So what it says is that on the death of the first spouse, their share, their 1/2 of this $3 million combined estate is going to pass through their will into this tax protection trust. How does this work? What does this mean? When I say pass through their will, that means there will be a probate. There will be a probate process, and that will cost money and legal fees, because I don't recommend that you do it yourself. You can try, but I don't recommend it. So there'll be a probate. The attorney will help you. The $1.5 million will go into this tax protection trust for the benefit of your surviving spouse. This trust is called a bypass or credit exclusion trust because what it does is it captures the decedent's credit exclusion amount. Remember I said it was $2.193 million? So their 1.5, their half of this $3 million estate will go into this protective trust for the surviving spouse and for ultimate beneficiaries. Okay, so this trust is set up. 1.5 million is in it because the first spouse has died. What happens when the second spouse dies? When they die, all that they have in their own estate, their own ownership, is just their 1.5 million. The 1.5 million that was the first spouse's to die is in this trust. And because it's in this trust, it will pass on the second spouse's death with no taxes imposed on that 1.5 million that's in the trust. And because the surviving spouse only had that, their share, their 1.5 million, that's under the Washington amount, which is 2.193. So by having all this plan set up with the tax protection trust in the wills, the estate passes and there's 0 estate taxes imposed, as a contrasted to perhaps 100,000 being imposed. So by just some very basic planning in your wills to have these tax protection trusts, you are going to ensure that there is going to be no taxes imposed on either the death of the first spouse or the second spouse. Nobody wants to pay taxes beyond what they need to. I mean, that just makes sense. So why pay an extra tens, if not hundreds of thousands of dollars to the state of Washington if you don't need to do so? So that's the number one planning technique to protect assets for your spouse and for your beneficiaries. Have a tax protection trust in your will, in your estate planning documents, if you have an estate that is beyond the 2.193 million. There's a lot of other strategies that I'm not going to get into today. There's, gifting you can do during lifetime. There's charities you can give to. There's irrevocable trusts you can do during your lifetime. There's all sorts of various other estate planning techniques. I'm not going to get into those. I just wanted to share with you a very simple estate planning technique to avoid paying Washington any taxes that you don't need to pay them. All right, let's move on to number 2, which is what strategies, what techniques are there to protect assets for your spouse against long-term care costs? This is a much more salient concern. If you look at the statistics, people that are over a certain age, over the age of 65 or 70, it's not a possibility statistically that they'll need care. It's a probability. Everybody is different. You know how statistics are. But if you are concerned about long-term care costs, well, you're right to be concerned. I mean, they can run from $2,000 to $3,000 a month for some extra help at home. To an adult family home might be $5,000 or $6,000, similar to an assisted living or memory care, $6,000, $7,000, talking per month. To a skilled nursing facility, which will be $10,000, $11,000, $12,000 per month. So you're right to be concerned about long-term care costs. And many of us have had experience with our loved ones, be it a grandparent, a parent, or a spouse, or friends. We know that this happens. And this is something it just makes sense to plan for. Plan for long-term care costs. If you've got long-term care insurance, fantastic. Keep it in place. Don't let it lapse. Majority of people don't have long-term care insurance. So what can we do? The most effective tool that we have as an estate planning and elder law attorneys is the type of a trust we put in your will. It's called an asset protection supplemental needs trust. Now, this kind of trust is specifically intended to protect money against long-term care costs. How does it work? Well, let's take the same scenario. Let's say $3 million, but you're in a situation where you are concerned that either you or your spouse, maybe you have a family history of dementia or Parkinson's or cardiovascular events, strokes. I mean, it goes on and on. You have $3 million, and let's say your house, is worth $750,000 or $1 million. I mean, you have a pretty substantial estate, but you're really concerned about long-term care costs because there's been a diagnosis, or you expect that there might be, and you don't have long-term care insurance, for example. Even if you do, what would we do differently than that taxable estate planning? It's similar. We'd set it up with, you would each have a will. And in the will, you have this asset protection supplemental needs trust. Now, how this trust is different is that it's called a discretionary trust. Whereas if you're just doing tax planning, you might have it what we call a standards trust for health, education, maintenance, and support, which is appropriate under certain circumstances. For example, you're not concerned about long-term care costs. The discretionary trust, why it is special, why it works, is that any money in that type of a trust isn't counted by the state, by Medicaid, as belonging to the surviving spouse for purposes of Medicaid long-term care benefits eligibility. And you might be saying, Lynn, why are we talking about this? We have $3 million. It's really a matter of simply doing some math. Alzheimer's diagnoses can be required care for 10 or 15 years. If you're looking at $150,000 a year over 10 years, that's 1.5 million. Add another 5 years to it, you're over $2 million. This happens. Doesn't happen in everybody's case, but I'm just taking this scenario to show you why, even with an estate as large as 3 million, you might consider an asset protection trust. So here's the example. Clients are a couple, they're 75 and 80 years old. The 75-year-old wife has a diagnosis of Alzheimer's, and she is physically pretty robust. The husband is fairly frail. The husband dies first. Wife is not going to be able to stay in her home. She needs a memory care facility. What happens? Well, on his death, the first spouse to die, his $1.5 million goes into this asset protection supplemental needs trust. Okay, what happens next? The surviving spouse, under Medicaid's rules, and I'll talk more about this at a different time, but if a surviving spouse is a single person, so they have to comply with Medicaid's rules for a single person for the state to pay for the person's care. Well, the state says that she can have $2,000 in countable resources, nothing. It's an impoverishment standard. But the state also says she can have her house, and that won't interfere with eligibility. So this couple had 3 million. 1.5 goes into the trust. What doesn't go into the trust? Her house, which is worth 750, let's say. She's got 750,000 in her own name. Without doing anything more, she will need to spend down that money. There's many other strategies that exist, but let's say she does nothing more, she spends it all down. So when she is at $2,000, she will qualify for Medicaid, despite the fact that she has a house that's worth $750 and it's in her own name, and she's got $1.5 million in trust. State does not count the $1.5 million in the trust, and the state allows her to have a house worth $750,000. Our standards just changed as of July 1st of 2022 to increase the limit on home equity to over $900,000 that a single person can now have. So what's the outcome of all this? Well, after the husband dies, the wife needs to move into a care facility. If you're familiar with long-term care at all, you know that oftentimes memory care facilities have a 2 or 3 year private pay anyway, before they'll accept Medicaid, even if the person would otherwise qualify for Medicaid. So she uses her excess money. Maybe there's other strategies we do, but she pays for her private care. And then when she's down at $2,000, she applies for Medicaid. And then now the state is paying for her care at that very same facility. She does not move. She's been there for 2 to 3 years. She has spent down through various techniques to $2,000. She owns her house. She has $1.5 million in trust. She's Medicaid eligible for the rest of her life. She is Medicaid eligible, and the state will pay for the care for the rest of her life. This is one way to make sure that your surviving spouse never becomes impoverished. She's got a $1.5 million nest egg. She also has the house. What other strategies exist to preserve those assets? Subject for another day, but there are strategies. I use the 3 million just so that you could see that it's not just somebody that only has $300,000 or $500,000 combined estate. It's a strategy that, depending on your circumstances and the diagnosis that you're dealing with, you might consider an asset protection trust through a will, even with that size of an estate. Obviously, if the estate is worth less, if we have an $800,000 total estate, clearly that is a very appropriate circumstance to do the type of asset protection supplemental needs trust in your will. I'll just go through that example really quickly. Same facts, except for there's less money. Husband dies, $400,000 goes into a trust. Wife survives, she has a house worth $400,000. She's immediately eligible for Medicaid, immediately. Now, I just said that there's a 2 to 3 year private pay, how she's going to get through that. Lots of ways. She can sell the house when she's on Medicaid, lots of strategies to preserve assets there, or the money in this trust is there for her to pay through that private pay period. The outcome is the quality of care will be good. There's money to pay for it. The assets will be there for the rest of the surviving spouse's life. They'll never become impoverished despite Medicaid's rules. And Medicaid will pay for care once that private pay period for the facility has been met. And when the surviving spouse dies, the money, there will be money left to go where they wanted to go, to their kids, for example. So this, from an estate planning and elder law perspective, is something that is so important for me to share with you and for you to share with anybody you know that might, you might be aware of a couple that one of them has a diagnosis that is going to lead to long-term care, because so many people don't know about this. They think that there's no way to protect assets for their surviving spouse when they're gone. No, that's not true. There is this very effective planning technique, a will with an asset protection trust. And that's what I really want to make sure that I share with you today. Now, you heard me say it's a will with an asset protection trust. This protection of assets against long-term care costs, against Medicaid, cannot be accomplished through a revocable living trust. Most people are familiar and have heard the term revocable living trusts, and the selling point why revocable living trusts are beneficial, everyone believes, is because they're intended to avoid probate. That is true, and in many circumstances, a revocable living trust is a great estate planning tool, but not for what I'm talking about today. What I'm talking about is, how do you protect money for your spouse against long-term care costs so that they don't become broke? You can't do that through a revocable living trust. The state of Washington will not recognize a revocable living trust as protecting assets for the surviving spouse against long-term care costs. Because if you did the same situation and you didn't use a will, instead you used a revocable living trust, what happens? Yes, you avoid probate if the revocable living trust was set up correctly, but the money that is in the trust for the surviving spouse, once a first spouse has died, all has to be spent down. It is not protected. The state of Washington says that money in the trust is countable against the surviving spouse for Medicaid benefits eligibility analysis. What does that mean? They need to spend it all down. What good did that do? Why have a revocable living trust with an asset protection supplemental needs trust in it if it is completely ineffective? And if you do have a revocable living trust and the lawyer told you, oh, this is a great planning technique in Washington, I would suggest that you talk with them further and ask them specifically. I heard somebody talking on YouTube or on a webinar, and they said that in the state of Washington, so that Medicaid doesn't count the money in this trust, that it has to be a trust created by a will. Is that true? The attorney will answer you, yes, it is true, if they know anything about what they're doing. Then you say to them, well, why do I have a revocable living trust? Well, because you know, I don't know what they're going to say, because what has to happen, and there are a number of practitioners who use revocable living trusts, and what they fail to disclose to their client is, we're setting you up for probate anyway, because probate is the only way that a will can create a trust. So even though you have a revocable living trust, if you look closely, it says it's going to pay to your estate. What does that mean? Pay to your estate means it is going to go to your will and going to go through probate so that you get the asset protection. So one of my goals is to share information, to educate, to be as transparent as possible. And one of my real concerns is when attorneys are disingenuous and don't tell you everything that you should know so that you can make an informed decision. And if you have a revocable living trust, that's a red flag. When any client comes into me and they have a revocable living trust and they say, well, I was told that it would avoid probate and it would protect assets against long-term care costs, then I have to say, I'm sorry, I have to tell you it won't work. And we have to do a new plan for you that is based on a will. And they say, well, if it's based on a will, that means there's going to be a probate of the will. That's the only way to create the trust, right? And I was told probate is bad. That's why people want revocable living trust, because they've been told, understandably, that probate is bad. Probate isn't bad. Probate isn't good. Probate is a legal process. Is probate beneficial to your estate? Well, as I just explained in how to protect assets so that the spouse won't go broke and will get Medicaid and the state to pay, probate is very beneficial. If you can protect 400,000 or 1.5 million or whatever the amount is, so that the state doesn't count it and interfere with Medicaid benefits, so that the state will pay for the care, that's not bad. Probate is beneficial. Probate is, so the question is it not bad? Is it good? Does it benefit me? If there is no benefit to your estate, to you, to your spouse, of course, we don't recommend probate. We recommend a different manner of setting up your estate plan, different tools. So when it comes to probate, really the question is does it benefit me? And help me understand probate more. And if it doesn't benefit me, my estate, then what other planning techniques are there? We've got other webinars and other places you can look to talk about probate and why you should avoid it. So I just really wanted to, explain that, because a lot of people have the misconception that probate is bad. No, probate can be very good, and probate can make sure that your surviving spouse will never become broke. All right, that wraps up the number 2 technique that I was going to talk about for how to protect assets for your spouse. Now, what you might see is what I've been talking about is what happens when somebody dies, how to protect assets so that unnecessary estate taxes aren't paid and that an unnecessary Medicaid spend down doesn't have to occur. So that's what happens when somebody dies. And we explain to our clients, these very robust, very protective trusts are there, and they're going to protect your surviving spouse. And then they say, but that means we don't have a trust right now. We're both alive. And it's like, that's right. You don't have a trust right now. Your trust is in your will. Your will has no effect until somebody dies. Oh, so there's no trust right now. No. And so understandably, the next question would be is, well, then how do we protect assets for both of us if one of us becomes sick and one of us needs long-term care, expensive long-term care, but we're both alive? What do we do then? This gets us to the 3rd planning technique. Both spouses are alive. You've probably heard about Medicaid spend down, Medicaid's 5-year look back. It's an impoverishment program. You can't keep any money, et cetera, et cetera. Pretty much all of that is true. So what do we have as an estate planning technique to make sure that the couple does not need to spend down all of their money while they're both alive? So this gets back to the very important estate planning tool that's called a durable power of attorney. What's a durable power of attorney? That is a legal document that you sign while you're alive, while you're competent, while you have capacity, and you grant authority to somebody else, somebody you trust, to make decisions for you on financial matters and on healthcare matters in case you can't for whatever reason. So how does that fit into protecting assets? All right, let's say you've come to our office and we've prepared for you the durable powers of attorney. One is for health, one is for finances. We like to separate out our durable powers of attorney. When it comes to protecting assets, we're talking about financial powers of attorney. So in your financial durable power of attorney, it's called durable because it stays in effect even if you lose the ability to manage your affairs. So it's durable. So in your durable power of attorney, you've designated your spouse to act on your behalf if you can't. Okay. What happens next? Let's say you're in a care facility, you have dementia. Why does this durable power make any difference? It's because your spouse now has the ability to do the planning that is available to qualify you for Medicaid, even though you have more Medicaid, more money than Medicaid says you can have. We're going to be doing a whole webinar on Medicaid planning and techniques. What I'm hoping to share with you today is why it's important that you have good, comprehensive, durable powers of attorney for finances that anticipate the possibility of Medicaid planning. Because as an elder law attorney, what I often see from other attorneys who don't have the Medicaid expertise is they do not include the necessary grants of authority that allow us to do Medicaid planning. So the necessary grants of authority in a durable power of attorney would include the property to revoke a community property agreement and to enter into a new property status agreement that says everything is the separate property of the well spouse, the community spouse. Other grants of authority include the ability to do gifting that exceeds the annual exclusion amount, which most people think of it as 10,000, then it went to 15, 16, it's slated to go up to 17,000 a year. When we're doing Medicaid planning, oftentimes gifting is something that we want to do. You're going to say, Lynn, but gifting has a Medicaid 5-year look back. We can't do that, right? Not necessarily right, not necessarily wrong. Yes, there's a 5-year look back, but there's no 5-year look back between spouses. We want to make sure that this spouse not needing care, all the assets of this community are owned by the well spouse. So we're going to need to do a separate property agreement, put everything into their name. Why do we need to do that? Well, because for the ill spouse to get on Medicaid, they are supposed to have only $2,000 in countable assets. We sure don't want the house in their name. We're going to want to quick claim it over to the well spouse, do a separate property agreement, move all the assets over into the name of the community or the well spouse, so that upon the 1-year eligibility review, the Medicaid spouse stays on Medicaid and the state never has a claim against those assets. So I have seen nursing homes and other people who are non-Medicaid attorneys get somebody on Medicaid, but they forgot to do all the work that has to be done to avoid the state's lien. So there's all sorts of things that I want to see in a durable power of attorney so that my hands aren't tied when I'm working with the other spouse to get the ill spouse on Medicaid. One of the things that I just want to share with you today, because people say, okay, we have $800,000, our house is worth $400,000, and we've got $4,000 in investments, and Medicaid standards, just to share with you, they basically say you can have 55, 60,000 up to about 130, 135,000. That's all you can have. You can't have 400,000. So most people said that I talked to my friend or somebody at the church or this or that, and they said, I just need to spend down all my money. If that's the case, and if you hear that and you have the ability to share with people, there is something that's called a Medicaid compliant annuity. So let's say somebody has 200,000 too much in countable resources, 300,000 too much in countable resources. Can they go on Medicaid? Can the ill spouse qualify for Medicaid? The answer is yes, they can. With zero spend down, they can keep all their money in the name of the well spouse. Well, I just said they can only have, 60 to 135,000. How does that work? We take the extra money, the extra countable money, the well spouse buys a Medicaid compliant annuity. By taking money and buying this annuity that Medicaid allows you to have, you've taken countable money, a resource, and made it non-countable, a non-countable asset. The state doesn't count this annuity. So you put the extra money in this annuity. Let's say it's 240,000 needed to go in the annuity. Maybe they did some spend down, repaired the house, did this and that. They don't have to spend down all their money. You take the extra money. In my example, I'm saying 240,000. You buy the Medicaid annuity in the name of the well spouse. Well spouse gets to keep all the money in the bank. It's a range between the 60 and 135,000, and they have a $240,000 annuity. Is that money gone? It's not gone. It will pay back to the well spouse over a period of 5 years or 60 months. I made it 240,000 because I can divide that by 60. So $4,000 a month, if I did my math right, comes back to the well spouse every month over the next 60 months. And they do not need to take their income or their annuity money and pay for the ill spouse's care. The state pays for the care and by the ill spouse's income, and the state pays the rest. Well spouse gets to keep all the assets, gets to keep all the money that comes back from the annuity, didn't have to spend it down, and this couple never loses their house or any other asset that they have to the state when the ill spouse dies. So these are durable powers of attorney, and to do these kind of very effective strategies, they need to be the durable powers of attorney that an elder law attorney would prepare, because we know what Medicaid's rules are. And so we include provisions that a Medicaid planning attorney would include, and an attorney not familiar with Medicaid likely won't include. So both spouses are alive, ill spouses on Medicaid, the couple got to keep all their money. Notice I used the couple that had 800,000. I did not use in that example the couple with 3 million. Why is that? Because I would not recommend that strategy to the couple that has $3 million. It simply doesn't make sense from a financial investment perspective, from a Medicaid annuity perspective. It, in my opinion, would not be appropriate, and I would not implement it. So that's what I mean by I'm very transparent and candid with my clients. I recommend it if you're at this level, not if you're at that level. All sorts of various factors go into the analysis of what is an appropriate Medicaid planning strategy. All of that aside, I used examples to show you what could be done, but the point of it isn't the Medicaid strategy. I will talk about that at a different time. The point of it is to do this strategy, I, as the Medicaid lawyer, needed to have the right powers of attorney in place. And I don't always have those in place if they've been prepared by a different law firm. All right, questions in the chat here. There's a question about, can the strategies 1 and 2 be combined into one trust? Remember, strategy 1 was the taxable estate credit shelter trust. Strategy 2 was the asset protection supplemental needs trust, the discretionary trust that Medicaid doesn't count. Great question, because this strategy number 2, asset protection supplemental needs trust, discretionary trust, Medicaid doesn't count, that actually is a tax planning trust as well, because the deceased spouse's 2.193 million credit exclusion is preserved by using that second type of trust, the asset protection trust. So it does serve as a tax planning trust as well. Now, there's a couple of differences between these trusts. When we're talking about just tax planning, avoiding Washington's estate tax, that's all we're talking about. We're usually talking about that tax planning trust and not the asset protection type of Medicaid trust. Why is that? Well, with this first kind of trust, this tax planning trust only, it's a standards trust, and the surviving spouse can serve as their own trustee, which means they got to be in charge of the money. They got to make sure that if they want something from this trust, they can write their own check. And upon their death, this trust usually goes wherever the first spouse said they want it to go. But the difference is the surviving spouse has control over that tax planning trust. Contrast that to the asset protection supplemental needs trust, that Medicaid discretionary trust. Surviving spouse cannot be the trustee. They cannot be in control of the money. The state says if they're in control of that money, they've got way too much control over it, and the state won't exclude the assets in that trust from being counted for Medicaid purposes. So it defeats the purpose. The idea about it was all this money in the trust is there available for the spouse. They simply can't be their own trustee. So it's an issue of control and protection. The more control, the less protection. But even with this, where the surviving spouse can't be the trustee, maximum protection, including tax protection, there will not be an estate tax imposed upon that when the surviving spouse dies from the assets in that trust. So yes, the strategies can be combined. Oh, and one other thing that I want to mention, there is the ability to say this first tax planning trust, we didn't know that there was going to be any problems with long-term care in the future. It can spring into being the other type of trust, the trust that Medicaid allows. But why does it spring? Well, the person was in great shape, surviving spouse, and I don't know, they had a stroke or they were in a car accident or something happens where they need asset protection now, not just against estate taxes, but for long-term care costs. That trust can convert into the asset protection discretionary trust. Obviously, surviving spouse can't be the trustee. There is the ability to spring into the other type of trust. Another question. If you're not married, but you have a longtime partner, it's a great question. So the third issue that I had talked about with how you can use a Medicaid compliant annuity, that only works for spouses and registered domestic partners. But the estate planning techniques about the trust, the tax trust, and the trust for asset protection against long-term care costs, yes, you can use those for a non-married person. Let me say, one of the things I don't want to get confused about is the tax laws say that when a spouse dies, there's not going to be a tax imposed on the first spouse's death. When a non-married person dies and the level is above the 2.193 million, there will be an estate tax imposed by Washington. So Yes, there are techniques to use trusts so that the survivor of a couple doesn't have to pay taxes on the survivor's death, or you can protect assets against Medicaid. But I don't want to confuse this. When a married person dies and their spouse is a US citizen, there's not going to be an estate tax imposed. That is different than when they're non-married couple and the first spouse dies. These are both single people, even they're in a committed intimate relationship or long-term partners, whatever. If a single person dies and their estate is above the 2.193 million, and that's going to go to a person or a trust for a person, any amount above the 2.193 will be subject to Washington's estate tax. Sometimes part of the planning is, would it be better from a tax perspective to get married? Or sometimes it could be, well, you don't want to get married because you don't want to lose benefits from a prior spouse, maybe become, a domestic partner. There's all sorts of various, factors that could go into it. But I just want to clarify that single people are treated differently than a married couple, a single person in a long-term relationship. The tax rules are different. Hope I didn't confuse you on that. If so, let me know. I'll try to explain it better. All right. Okay, well, we're coming up to close to the end of the hour here. Thank you for all of those. If there's no more questions, I'll let you know that for everybody who is alive, we're going to be sending to you our free gift, which is our free guide to estate planning ebook. It is obviously not as specific as all the questions I went through and the techniques, but it is a really good guide to take a look at. So we'll be sharing that with you. And if you have further questions, just reach out to us. We're ELG Estate Planning, and we can be found at elgwa.com. You can call us at our main number, which is 509-468-0551. It's there in the chat. So thank you, everybody, for being with me today. I hope that I was able to share some good information with you. And if you found it helpful, feel free to share it with others, and stay safe, everyone. Thanks so much.